Hi, I'm Paul Vacheski, NebraskaLandlord.com. Today we got another video covering notices. In 2016, the legislature decided to pass a brand new notice. This is a landlord-only notice to deal with what we call the clear and present danger issues. So it comes from Nebraska Revised Statute 76-1431. Some of you may be familiar with that particular statute. That's where we find the other notice requirements in the law. And just real briefly, we have the 3-day notice that's in the Nebraska statute. That's only for the non-payment of rent. The tenant doesn't pay the rent, then we use the 3-day notice. It's a landlord or property management notice. We have the 30-day notice, and that's for some other breach other than the non-payment of rent. Now that is for landlord and tenant, so a tenant can actually serve the landlord and should serve the landlord a 14-day notice if the landlord is in breach. But in this case, what we used to have is, before the 5-day notice, is maybe we had a tenant that was dealing drugs, maybe we had a tenant that was very violent, those type of things, that was actually a clear and present danger to not only the property, but to you and the other residents in your community. Well, the only tool that we had to deal with it was a 30-day notice. And you know, we were given them 14 days to stop dealing drugs, and then we would give them a 30-day notice, or it would become a 30-day notice, and they'd have to move, and you'd have to prove it, and it was a mess. The point is, this was a worthless notice when it came to those types of issues, and it really put us at a lot of risk. So the legislature, they cured this problem by passing and implementing the 5-day clear and present danger. Now, it is very specific in the type of activities that the tenants are doing, and I don't want to miss anything, so I'm going to read right from here. It says, if your tenant is engaged in any violent criminal activity on the premises, 2, engages in any illegal sale of a controlled substance on the premises, or engages in any other activity that threatens the health or safety of other tenants, the landlord, or the landlord's employees or agents. Okay, that's how it's not and, it's or, any one of those three. Then we can serve a 5-day notice to our tenant. Because of that activity, they're gone. So after the 5 days, then you as the landlord can terminate the lease and move forward with an eviction suit. Now, it is incurable, unlike the 3-day and the 14-day notice, where if they paid the rent within the 3 days, then they're fine. Or here, if they were to stop doing the activity within 14 days, these two are curable. This one is not. Even if they stop selling drugs, we can still proceed with the eviction. Now, there is an exception to the curable part of it, and I just want to make sure I get this right. So let's say it wasn't the tenant that's on the lease, it wasn't their activities, but let's say they had a guest, and the guest was started a fight on the premises. So it's the guest that's the troublemaker. The guest is the one who is dealing the drugs. Well, we would serve the same 5-day notice. Now, it does become curable by the tenant that's listed on the lease agreement if one of two things happen. So if the tenant seeks a protective order, a restraining order, or other similar relief which would apply to the person conducting the activity. So let's say that the tenant went to their guest and said, here's a restraining order, actually went and got a restraining order that said, please stop, with the violent activity or something like that. Or number 2 is the tenant reports such activity to a law enforcement agency in an effort to initiate a criminal action against the person. So in that case, we would serve notice to the tenant on the lease, and then the tenant would call the police and say, hey, my guest is dealing drugs, my roommate, can you get him out? In that case, because now it's documented, it is curable, so they could use that as a defense to the eviction action, okay? Now, one last thing here, 2 things actually. This is very important. Under the statute, or on its face here, all right, the law does not require a criminal conviction. It does not require a criminal charge or even an investigation. It really is just if the landlord believes that such activity is going on that creates or constitutes a clear and present danger. Sometimes we have documentation. Maybe there's a domestic violence issue that went on and the police were called. So now we have the police report. Okay, so we might have documentation, but under the law, it's not required, okay? It's only what we believe. So if we believe there's activities that constitutes a clear and present danger, then we can do it. Now, one thing I want to caution you on before you submit a 5-day notice. It's a brand new law. It hasn't really been vetted by the courts. And I do think there could be some potential fair housing issues with this. So here's my recommendation. If you suspect that there is some kind of criminal activity or some kind of clear and present danger activity going on, before you give your tenant a 5-day notice, make sure you have a conversation with your lawyer to make sure you're in compliance with fair housing when doing this. Lastly, down in the remarks, I do have an actual 5-day notice that you can print and take a look at. I'd like to thank John Chatelain, he's the president of the Metro Omaha Property Owners Association, for letting me post his 5-day notice for use in this video, so you're more than welcome to take a look at it. Other than that, if you have any questions, please, in remarks, ask your questions. I'll return with an answer. I'd love your comments, thumbs up, thumbs down, like our Facebook page, subscribe to our YouTube channel. And that's it for today. I'm Paul Vacheski, NebraskaLandlord.com. Until next time, happy landlording.